in every case. I did.
And when you give a client a to-do list in your practice, does that mean that a divorce is imminent?
Typically, yes. Yeah. You know, I've been around a long time, and this is a small town, small county, and so there are people that will come and meet with me to try and conflict me out of a case. And after so many years of practicing, you learn pretty quickly that that's their intent, because they want to take our 3 or 4 hour meeting and do 15 minutes and call it good. I can typically, some of those people retain us, others just want to know the information that I have, because like I said, I'm trying to teach them all about divorce and what life looks like after divorce.
So giving the to-do list, how is that significant in your practice? Would you give that to someone who wasn't going to proceed?
No. If I have somebody that comes in and they're either trying to conflict me out, or they just really want to talk about what this might look like in 30 years down the road, there's no to-do list. Sometimes I won't even fill out the questionnaires that I have, the question papers, the blue sheets. But if they have a to-do list, people are, in my experience, it is anticipated that they are going to file for a divorce at some point in the future.
And Eric walked out of this meeting with a to-do list from you.
He did not want to take it with him.
Oh, that's right. He didn't leave it, but you gave him a to-do list. Is that
Correct.
right?
He wanted me to correspond through his brother-in-law, Clint. So I emailed the to-do list to Clint.
Did you refer Eric Richins to anyone after or during your meeting with him?
I did.
Who did you refer him to?
He had worked in the past with Crystal Bowman Carter to do his business planning documents, and he needed to revoke a power of attorney. So he was going back to Crystal for that, or I told him to go back to Crystal for that, and also to redo an estate plan.
Okay. Was it unusual in your practice to refer someone in Eric Richins' position to a lawyer like Crystal Bowman Carter?
Yes.
Why is that unusual?
Because most people going through a divorce, in my experience, aren't thinking beyond what that divorce might look like. They're not thinking about death or estate planning and so forth. And most people, once you file for divorce, you cannot change any beneficiary and so forth. And so that was not a rule at that time in 2020. It's a rule now, but it was unusual. I've only referred one other person in my memory to change their estate plan while a divorce was either pending or before they filed for divorce.
So Eric went through this initial meeting with you. Did he ever file for divorce with you?
He didn't.
Or through you, I suppose?
No.
And did you discuss a timeline with him about filing for divorce?
I did not discuss a timeline with him. As I said, well, I didn't say this, but because divorce is so emotional, and there are so many things to unravel, kids and finances and debts and family and external family and extended family, and everybody really is on their own timeline. like I said, I have a couple clients currently that I've been meeting with them for 10 years off and on. So they're not ready to pull the trigger, and everybody has a different timeline.
Thank you. Those are all my questions for you.
Good morning, Ms. Miller.
Morning.
My name is Wendy Lewis. I am one of Ms. Richins' attorneys. So I think you stated on direct already, but it wasn't Eric Richins that reached out to set up an initial appointment with your office, correct?
That's correct.
It was his brother-in-law reached out, and not just to say, hey, I'm referring someone to you, but he reached out to set up the appointment, correct?
I don't recall whether I wouldn't have been part of that conversation. That would have been with Leslie, my paralegal.
Can we take a look at CM1 just for the witness? Let's see if that's the right one. Okay. Let me just ask another question before we talk about that document.
Sure.
Two more questions. So you do remember that it was Mr. Benson that reached out, and then you set up a meeting with Eric. Did anyone attend that meeting with Eric, or was it just yourself and Mr. Richins?
It's my understanding, Eric contacted my paralegal to give her a lot of specifics about his situation. And then the meeting that I had with him was just the two of us.
All right. And after that meeting, it was Mr. Benson that reached out and thanked you for meeting with Eric, correct?
Yes, Eric did not want me to have any contact with him via phone or email directly. He wanted everything to go through a third party, his brother-in-law.
Okay, that's what I was getting to. So when you gave Eric the list of documents, you actually sent that to Mr. Benson.
That's correct.
And then it was actually Mr. Benson who provided you with the documentation over email. I don't know, Eric may have brought some things in person, but anything that came over email was between you and Mr. Benson, correct?
Correct.
And would one reason that a client would ask for that, would it be because they weren't ready to let the spouse know that they were considering divorce? Is that fair to say?
Yes.
All right. And a reason for this, and I mean, I know you said that most people who come in and go this far do end up filing for divorce, but fair to say that some people aren't certain if they're going to file when they come in to see you, correct?
Very few.
It happens though.
It does happen, yes.
All right.
When curiosity strikes about the everyday lives of your family, we're here with answers only your ancestors can provide. See their stories at Ancestry.
Involvement in divorce, correct? I might be naming that form wrong, but you said you went through forms about children.
Children's Bill of Rights.
The Children's Bill of
Yeah,
Rights.
it is not an official thing in Utah, but I have it and I give it out on it. I'm very color coordinated, so I've colored pens for various things, colored paper for the initial client consultation. That happens to be on purple paper, and it's taped up all over our office as well, so I can remind clients, this is the sun, your kids are the sun, and we're all rotating around them. So let's keep our eye on the prize. So it's just, it isn't anything you could enforce in court, but it's something that I like to share with clients.
Sure, because clients with small children, that's a huge consideration, is what will happen with the children, both financially and emotionally, and who the children will be living with. Fair?
Typically not financially, but emotionally, and who they will be living with and what the possibilities are, for sure, is a big concern for most people.
Okay. Finances are a concern, which is why you fill out a child support form with clients, correct?
Yes.
And can you pull up CM5? And you filled out a form with Mr. Richins about child support,
I
correct?
did, yes.
And he reported to you at that time his monthly income was $33,333, correct?
But based upon what, yes.
Okay.
Sorry, I was gonna say, I didn't have documents at the time, so we were just, this is more for kicks and giggles of, this is what child support would look like if this were the number.
Fair.
Yes.
And his child support was going to be, it was going to be high, correct? Based on his income.
Yeah, well, I mean, it depends on who you're thinking about. In Park
You're-
City, probably
you're
not so much,
absolutely
but for
correct.
most people,
That's
yes.
true. In
Yes.
my very small dalliance with divorce law,
Yes.
we were frequently, you see people whose income is, it's quite low. I'm going to say frequently. Some people it's quite low and child support's not very much.
You can have that for sure.
And for some people, this is a lot of people. $33,000 a month is a high income, correct?
Not for a lot of people that I deal with, but I think on
Okay,
the
fair.
whole, yes.
All right, you're dealing with some more, maybe fair to say no, didn't come out very well. High-end clients, high-end divorces with more assets.
I would say the longer you're in practice, the more difficult your cases become, and the higher the wage tends to be with regard to divorces.
Okay. Now, other things you discussed with Eric were assets,
Yes.
fair? And you were made aware that he was a partner in,
Objection, Your Honor.
I'm just asking if she's aware.
Forgive
we
me, what's the
approach?
basis of the objection? Sure.
It's hearsay.
Okay.
So in consulting with Mr. Richins and receiving documents from Mr. Clint Benson and maybe from Mr. Richins, you became aware, or were you aware, that Mr. Richins owned a couple of businesses?
I became aware of that during my conversation with Eric.
Did you become aware of that in any way through documents, tax information provided, other documents provided to you by either him or his family?
I did not receive any tax returns from Eric Richins.
Did you receive anything, documentation in terms of his businesses?
No.
Can I-
You
can
mean
I-
the business specifically?
Yes,
No.
or that the businesses existed?
Yes,
Documentation that the businesses existed?
correct.
Okay. And one of the businesses was C&E Stone Masonry, correct? Do you recall that?
Yes.
And Katie, can you just pull up? Good question. The next one, I think it's maybe CM6 or 8. I don't know. Help me out here. There's one moment, Your Honor. Just one moment. If you could just pull up just for the witness, CM7. So you became aware that he owned partner in C&E Stone Masonry, correct?
Yes. So this document.
Well, that's just refresh your
Oh,
recollection.
got it. Okay.
Okay.
Yes.
And you also became aware through,
I need you to ask the question to lay foundation for the how about the other businesses
I was
as
about to.
we discussed.
I
You
was-
can't ask it as a leading question.
all right. Let me back up a little bit. You said through documentation, you became aware of Mr. Richins' businesses, just that they existed.
The masonry business.
Did you receive documentation that he also was, he and you did not receive any documentation about any businesses existing, just the existence of the businesses?
No.
Okay, well,
Overruled. Now we have double confirmation. Please go from there, Ms. Lewis.
okay. Did everybody hear the whole?
I think it was 2 no's in a row.
Okay.
But
All right. Let's see. So now, I know Ms. Shervanek asked you, and you said it was true that Mr. Richins did not proceed with divorce in this manner, in this case,
Not
correct?
prior to his death. No.
And to your knowledge, he did not proceed with divorce with a different attorney. Fair?
Correct.
And you said that you referred him instead to an estate planner, estate attorney,
Didn't
an attorney who does estate planning. Thank you.
Yeah.
Sorry.
didn't refer him instead. I just referred him to Crystal Bowman Carter to work more in tandem.
All right. And you said you haven't done that very many times, correct?
Right.
But there would be reasons to refer someone to an estate planner. Fair? Just would there be reasons? Yes or no? And then I'll follow up.
At the end of every divorce case, I refer every client to, I give every client a very long, again, to-do list and a closing letter. And at the end of that closing letter, I refer everyone to, or I recommend that everyone see an estate planning attorney to
Okay.
revise their estate planning documents now that they are no longer married.
Okay. In this case, however, that happened earlier in the process than normal.
Yes.
All right. And just let me ask you a hypothetical.
Sure.
So sometimes people have concerns about their children. I mean, it's a fair reason that people don't get divorced when they have small children because they don't want to break up the family. Fair.
Yes.
And if an individual has concerns about providing, well, let me rephrase that. So hypothetically, someone may have concerns about how their children will be provided for during, after a divorce. Fair?
Provided for
Financially.
psychologically or financially?
Well, both, but I'm talking about financially.
Yes.
All right. So one reason someone may go to a estate planner could be to ensure that things were properly set up to provide for their family, whether they get divorced or not. Fair?
Are you talking about this early on in a potential divorce proceeding, or just generally?
I'm asking hypothetically, well, generally first.
Yeah, people generally go establish an estate plan to make sure that that if they have children, their children are taken care of, or that if they have assets, their assets are allocated the way they want upon their death.
Okay. And even though you said it's unusual, it's certainly possible that as someone is going through talking about divorce, they discover that they want to look at this now, prior to divorce. They want to set this up. Part one of my question, is that possible?
I have never seen that, but I assume anything is possible.
Sure. And it's possible that someone may decide, instead of a divorce, I need to set up a way to make sure my family's taken care of. That maybe that's the more appropriate thing for me to do at this stage. That's possible.
I think you're probably comparing apples to oranges. When, in my experience, when someone is ready to move forward with a divorce, or when a divorce has been kind of forced upon them from their other spouse, it is because we have, I explain it to clients as two pieces of wet noodle, and we drop them on a plate, and one is the emotional divorce and one is the legal divorce. And my job is to straighten those out and keep them as separated as I can, because at touch points, when the legal divorce touches the emotional side is in chaos. And when the emotional side touches the legal side is in chaos. And so when you're going through a divorce, that in and of itself is an apple, where people are worried about what their kids' lives will look like tomorrow.
Understood.
Or next month. When you are doing estate planning, it is, what will my kids' lives look like if I am not here, or me and my spouse are not here? Like, is grandma going to take them? Is my sister going to take them? And so they don't often overlap, because people in divorce don't often, in my experience, they don't even really think about their estate plan. It doesn't come up in our cases, except for a very small handful of
Okay.
cases.
I understand it's a very small handful, but let me just try and ask once more.
Sure.
It's possible that while going through what a divorce is going to entail, someone can change their mind, correct?
Decide not to get a
And
divorce.
decide not to get a
course.
divorce, correct? And then it is possible that they want to go set up an estate plan, correct? I mean, that can happen.
I'm sure it can. I've never seen it happen, but I'm sure it can.
Okay. You don't, okay, I'll strike that. All right, but that's what happened here. Mr. Richins decided to see an estate planning, a lawyer who specialized in estate plans, correct?
What happened was, I advised him to seek an estate planning an attorney to help him with what I perceived as his concerns at that time with regard to his finances and his children.
Okay, thank you. I have nothing further at this time. Thank you.
Ms. Sherman,
No other questions, Judge.
may we release this witness?
Yes.
Ms. Lewis, may we release this witness?
Yes, Your Honor.
You're free to go.
Thank you.
Nice to see you.
Thank you.
Am I taking that cup with you?
Of course.
And your leave the binder there. If you don't. Oh, is that your binder?
No.
You can leave it there. Okay.
Thank you. Take care, Ms. Miller. Council, any objection to breaking for lunch?
Whatever the court wishes.
Ms. Lewis?
No, Your Honor.
Okay, folks, please rise for the jury. During the break, ladies and gentlemen, same instructions. Don't talk about the case. Don't read, watch, or listen to anything about the case. Do not do any research on your devices about the case. Please enjoy your lunch. We'll come back at 10 of 1. Thank you very much. Folks, have a seat. Thank you. Mr. Flood or Ms. Sherbanek, anything on the record before the lunch break?
No, Your Honor.
Ms. Lewis, Ms. Nestor, Mr. Ramos? 12:50. Thank you.